I'm Debbie Moraes, and this is Legal Matters, the program that's designed to address the critical issues facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics, as you know: finance, family law, Social Security, workers' compensation, and more. And last session we had discussed criminal law, the felonies, misdemeanors, what you do with a criminal case, the various stages of it. And as usual, we have our legal counsel who are addressing those issues and others. From Odette Bizarre Cordero Grasso Law Firm in East Providence, Jackie Grasso and David Bizarre. Thank you, welcome. We had talked about criminal law last time, and as usual we get a question from our viewing audience, and here it is. If you think about someone who's been arrested and is about to go to a court case, how do you evaluate whether it is in your best interest to plea bargain, especially if you're innocent? Jackie, David,
Attorney Bizarre?
Well, there's a lot of factors that go into whether or not someone's going to plea bargain. The innocent question is not usually a big portion of that, but if someone is not guilty of what they're charged with, more often than not, they're going to insist that they go to trial. But if there's any doubt, and sometimes things aren't black and white as to whether or not a case can be proved. I'm just trying to think of an example. Perhaps you're charged with filing a false document with the government. You know, at the time you filed it, the state has to prove that you knowingly filed something that wasn't true. That's maybe, in hindsight, it wasn't true, but at the time you filed it, maybe you had a good faith reason to think it was true. So you could probably have a good chance of being found not guilty at trial. But there's also a chance, given those set of circumstances, there's a gray area whether or not you might be found guilty. So in that type of situation, you're going to weigh and balance the cost of going to trial, which can be very expensive. What is the downside if you're found guilty? Appeals are expensive. What do you face for a sentence? Is there a jail possibility? And what are you getting in return if you do admit to doing something that's not correct? If it's a case like that and they reduce a felony to a misdemeanor and it's going to be filed, which means after a year you can get it expunged, you might accept a plea bargain in that situation, even though you think you're not guilty and could be proven not guilty at trial.
I would imagine, based on what you're saying, David, that that would really rely on or depend on you having a lot of faith in your lawyer whose advice you're going to be following. If I'm innocent, there's a part of me that says I want to ground my heels in here and make sure that I'm found innocent for all the world to know. And yet you might be suggesting to me that it might be in my best interest because of time, money, etc., that I should do this.
Right. In the example I gave you, you could go to trial. And you could put on all the evidence that you have to show that you were acting in good faith, you didn't know what you filed wasn't correct, and a jury of your peers could look at the evidence and say, it wasn't true. When you filed it, you should have known it wasn't true. How could you not have known? And you could be found guilty. So even though in your own mind, there's a good chance that you might not be found guilty because you think you're innocent, and there's a difference, of course, between not guilty and innocent, then you might accept the plea because you can get it off your record in a year, there's nothing that's going to affect you long term, etc. The most common situation is you have done something wrong. Maybe you've been charged with something that is a felony and what you feel you did should have been a misdemeanor. Aggravated assault versus a simple assault, something like that. Those types of things you're often going to reach a plea agreement on because you don't want to take the risk of going to trial and be found guilty of something more than you think you did. And if you have a situation where you're facing jail and you're offered a sentence of less than jail, oftentimes you'll accept a plea in those situations. But the state has to agree to it too. It's not like you can go in and say to the state, well, I didn't do this, but I'll accept X. And the state says, no, we're not going to give you a filing or a probation. We want jail. And if it's a situation like that, if it's a two-way street, if both sides don't agree, the case is going to trial.
Who initiates the question of plea bargain? Would it be the defendant or
the process is as follows. When you're charged with a felony, for instance, you have a pre-arraignment conference. Before you're even charged with the crime, you have a chance to go in and speak to a representative from the Attorney General's office and see if you can reach an agreement. Then before trial, there's a pretrial. The purpose of the pretrial is, again, to discuss a possible resolution of the case prior to trial.
Right.
So built into the system is a discussion. If you're innocent, not guilty, and you want to insist on going to trial, then you can waive those hearings and say, just wait, pass it for trial. Pass it along the calendar. When I'm reached by the court, I want a trial. And you have that right.
Oh, there's also the other fact is, if you're in district court, there's not going to be a jury, so you're not
Right.
convincing a jury of your peers, you're convincing a judge. So you get one bite at the apple with the judge, whereas with a jury, you get
Right.
several
Well,
bites to be proven not guilty. You have to have a unanimous verdict.
The jury verdict, as Jackie says, has to be unanimous. And the difference is, in district court, we may have spoken about this a little bit last time, is it's a misdemeanor. And you get one free bite at the apple, because if you don't like what the judge does, if you're found guilty by a judge, you have the right to appeal to have a jury trial. You waive the trial by jury in the first instance and let the judge hear it on a misdemeanor. If you don't like that result, you do have a right to have a trial de novo, which means brand new, in front of a jury.
Interesting. That was a good
Just
question.
one last thing. Regardless of plea bargaining, if it's superior or district court, the disposition that's agreed upon between the defendant's attorney and the state prosecutor, that has to be approved by the judge. And not every time will a judge approve the disposition. He or she may say, no, I don't want this. I want, instead of 6 months probation, I want 18 months supervised probation. So that has to be approved by a judge.
Right. The judge has the final say on accepting it, and the judge has to make sure the person who is plea bargaining, who's entering into an agreement with the state, understands what they're doing. So the judge will go through a whole litany of constitutional rights you give up. The right to a trial by jury, the right to confront and cross-examine the witnesses, the right to present your own evidence, the right to presumption of innocence, and the right to appeal the verdict. And you also give up the right to file a motion afterwards to reduce the sentence because you've agreed to the sentence in advance.
That's a lengthy but a very good question. I'm glad we
It also becomes more complicated if somebody is not a citizen of the United States, so
Right.
then you have a whole slew of immigration
Deportation.
issues.
Right.
Exactly. So what would normally be considered a misdemeanor in district court, for immigration purposes, they may look at that like a simple assault or a domestic assault. They may look at that as a felony, and it could subject the individual to deportation.
Right.
That's another topic for another day.
And the last word on this is that the judge will make sure whoever is pleading in front of them understands all those things before they accept the plea.
Good to know. Good to know. Well, thank you. Our topic for today is reverse mortgages. And I guess most people understand that if they have a mortgage, that your home, or if you have a home, that is your single best asset. And when we talk about reverse mortgages, it's one way that senior citizens can extract the equity in their home and get some cash out of it. Hopefully today we're going to be able to review some of the pitfalls, some of the flags, the traps, and hopefully you'll avoid some of the fairly common problems. And with Jackie and David here, let's go over some of the pros and cons. Why do people have reverse mortgages in the first place, basically?
An individual will want a reverse mortgage if they need additional funds to maintain usual and regular living expenses. For instance, somebody is living on Social Security income. The individual owns real estate, and they're maybe short $500 or $600 a month in meeting their bills for a variety of reasons. Taxes have gone up, medical bills have gone up. And so because of the shortfall, instead of having to borrow against the house and pay it back, provided there's sufficient equity in the house, you can get a reverse mortgage and actually use that home equity to pay the individual either in a lump sum or multiple payments, or they'll give you a line of credit. And you're free to do whatever you wish with the money. So you're actually using the equity to give you a supplement to your income,
Cushion.
and you're not paying it back with a conventional mortgage. You're paying the money back over time. The money does get paid back with a reverse mortgage, but it gets paid back when the homeowner either moves out of the house, passes away, or sells the home.
That's the big difference that people have to understand.